We are on to our last, but definitely not least, panel for the 9th Annual Texas Groundwater Summit. We are going to be talking current legal issues next. So we've got our panelists whose cameras are coming on. We've got one more that'll pop on. I'm going to turn it over to Greg Ellis, who is a familiar face, I think, to all of you. He is a fixture, a pillar of tagged and groundwater, who is going to be moderating this panel. And Greg, I'll let you introduce your other panelists.
Thank you very much, Leah. I think I'm unmuted. I want to also welcome two young attorneys, comparatively speaking here, who have become very involved in groundwater issues. Deborah Trejo with law firm of Kemp Smith, one of my attorneys when I was at the Edwards Aquifer Authority, and has become very, very involved with groundwater conservation districts and especially on takings issues. And Ms. Stacey Reese, who's an Austin solo practitioner, who just took on the job of General Counsel of the Lone Star Groundwater Conservation District. So, pardon the pun, she jumped in the deep end. So I'm very happy to have both of them here. We have a long slide presentation, a lot to talk about. I hope you all come up with a lot of good questions for us. And we're going to try and talk about not just the cases and what happened, but also kind of how this applies, what the impact is going to be to groundwater conservation districts across the state. And we're going to end up talking about the issues that have yet to be resolved. And I really look forward to a robust discussion there. Let's go to the next slide, please. I think we start off with Deborah talking about LULAC versus EAA. Go ahead, Deborah.
Hi, everyone. Thanks for joining us this morning. I hope everyone can hear me okay, and if you can't, Greg or Stacey, let me know. We're going to start off by talking about the LULAC case. That's the League of United Latin American Citizens, which is a longstanding civil rights organization that works on issues affecting Latino citizens. I represented the Edwards Aquifer Authority in this case. The case involved LULAC and 3 individuals in Bexar County, San Antonio, who sued the EAA and later the Texas Secretary of State. And they sued seeking declaratory and injunctive relief. The suit was to enforce the Equal Protection Clause of the United States Constitution. And they also had claims that were from the Voting Rights Act. The basis of the claims was that, still on that other slide. The basis for that claim was that the EAA, the Edwards Aquifer Authority, which is a groundwater conservation district that has 15 elected board members, has its director districts apportioned in a way that does not reflect one person, one vote. So that the 15 districts of directors for the EAA, each district is not of the exact same size. So the argument was that that was a violation of equal protection. Cases involving one person, one vote are litigated under the Equal Protection Clause of the U.S. Constitution. And so the argument was, as a result of the unequally weighted votes, individual voters, and in particular in Bexar County, were being denied their right to be treated equally with other residents, voters of the Edwards Aquifer Authority. I just want to tell you a little bit about the director districts and why they were established the way they were established, so that it's clear to everyone the reason for the different districts. So the Edwards Aquifer Authority, as you all I'm sure know by now, represented a tremendous compromise. An act, the Edwards Aquifer Authority Act that was passed in 1993, was a way to manage the Edwards Aquifer, which now provides water to more than 2 million residents in South Central Texas. But it is comprised of pumpers overlying the aquifer, or pumpers from different kind of classes. So you think of it as Bexar County are primarily municipal and industrial users, and there's a large population that largely relies on Edwards Aquifer groundwater. To the west, in western Bexar County and in Medina and Uvalde and a little bit Atascosa, to the west, we have large irrigation areas dependent upon the Edwards Aquifer. And then east of San Antonio in Comal, Hayes County, and we have parts of Caldwell and Guadalupe counties, we have spring flow dependent use. We have some wells, but we have spring flows to San Marcos and Comal Springs, which ultimately feed to the Guadalupe River. And there you have, in addition to some pumping from the Edwards Aquifer directly, you have a large number of folks who are dependent on the spring flows and river flows that result from the Edwards Aquifer. So the way that the Edwards Board was created as a compromise was that even though it had the larger population, Bexar County, who had been and still is the largest pumper of water from the Edwards, wouldn't dominate all decision-making. So the legislative compromise was we'll have 15 directors, but only 7 out of 15 can be from Bexar County. So there's 7 seats in Bexar County, 4 west of Bexar County and 4 east of Bexar County, so that there'd be a balance built into the governance structure of the board to represent the regional interests that depended upon the aquifer and to get the legislation passed. Otherwise, this bill wouldn't have been passed. And those seats were actually crafted in an amendment to the EAA Act in 1995 before the act became effective. It was passed in 93 with appointed seats. It got amended in 95 under the guidance of the Department of Justice, and these 15 director districts were created. So I know there's a lot of background, but so there's sort of recognition of different uses and different dependence of the aquifer in crafting this legislation. So that's the background. And interestingly, that compromise on seats was an agreed to compromise, including by LULAC, MALDEF, the Department of Justice. At the time, the seats were drafted in 1995 and approved by the legislature. Okay, so next slide. Okay, so in addition to LULAC filing the lawsuit against the EAA and the Secretary of State, San Antonio Water System joined as an intervener plaintiff on the side of LULAC and became a lead litigator in the case because San Antonio does not have one person, one vote representation. Cross motions for summary judgment were filed on the question of whether the EAA is a special purpose district, which is a district that's created for a limited purpose and scope and not a general purpose governmental body, and therefore not subject to one person, one vote requirements. And then whether those director districts that were created were balanced to reflect the different water interests that were the basis for the creation of the EAA in the first place. I'll add also there were some other interveners. This suit gathered a lot of interest, and some other interveners in the case on the side of the EAA were the New Braunfels Utilities, the City of San Marcos, the City of Uvalde County, and an amicus brief was filed by Guadalupe Blanco River Authority, and an amicus brief was filed by the City of Victoria, by the Texas Farm Bureau, and by current and former Edwards Aquifer Authority directors from not just the west and east, where the votes were apportioned with more weight, but also from Bexar County, because this was a compromise that San Antonio signed off on. So we had these cross motions filed with the federal district court to decide these legal issues about whether the EAA was a special enough district that it wasn't a general government in the way that courts had looked at this issue before. Because we know that equal protection requires that, for instance, U.S. congressmen that all of us be in exactly equally weighted districts, so that my vote for my U.S. congressman is, weighted exactly the same as Greg's vote closer to Houston. And we know that's true for counties, and we know that's true for school districts and community college districts, that those are all one person, one vote entities. But the Supreme Court has looked at only a small number of these sorts of cases, and they've involved irrigation districts and other special districts in the West where the boards were not set up with one person, one vote systems. So Edwards Aquifer Authority is different than those entities. It looks different. It has some different functions. And plaintiffs in this case, LULAC and San Antonio Water System, argued that the EAA does everything to control the lives of individuals in San Antonio. In fact, the pleadings in the case argued that the Edwards Aquifer Authority controls when residents of San Antonio can flush their toilets. So if you live in San Antonio, I'd like your feedback on that and whether you're allowed to go to the bathroom and what the EAA has to say about that. From where I sit, I've talked to a lot of people who've never heard of the EAA who live in San Antonio. So it was surprising to learn that the bathroom use was being controlled by the Edwards Aquifer Authority. But anyway, so that was a legal issue. That's what's being decided. Slide. So, well, the EAA prevailed on those cross motions for summary judgment for some of the reasons that I'm explaining, because it really is, the EAA really, and the district court agreed, really was just created to manage groundwater, just created to manage only one aquifer, the Edwards Aquifer. Unlike every other groundwater district in the state of Texas, the EAA only manages one of the geologic layers underneath its jurisdiction. Every other district manages whatever's groundwater beneath the surface. The Edwards has EAA only has one layer, the Edwards, and so it can't even manage Trinity groundwater or anything else. So the district court agreed with us that the EAA was a special district and it did meet this exception. And the plaintiff appealed. LULAC, San Antonio Water System, dismissed its claims in the suit and accepted that it had not prevailed and got out of the lawsuit. But LULAC carried the appeal to the Fifth Circuit Court of Appeals, where we had oral argument, and the Fifth Circuit affirmed the district court's decision on all grounds. Plaintiff LULAC, at the Fifth Circuit level, acquired a national law firm, a civil rights organization to help them litigate the case. That's who took the argument at the Fifth Circuit, and that's who filed their writ of certiorari at the U.S. Supreme Court. And they briefed and asked for the Supreme Court to accept review and consider. They argued basically that this case was really unique, that it was really important, and that the Supreme Court needed to take review so that basically special districts in Texas and beyond don't run amok and aren't proliferating in a way that impacts voting rights. I want to add for everyone on the call that while the case was strictly about the Edwards Aquifer Authority, that there are many other districts in Texas who are groundwater conservation districts who also have director district lines that are not based on one person, one vote. And I'll just share a few of those with you. The Barton Springs District, Evergreen, Winter Garden, Lippin, Kickapoo, Middle Pecos, Middle Trinity, North Plains, Panhandle, West Tex. So the case was important for ensuring that those compromises that were made to manage a natural resource that were based on recognition of the political necessity of not providing too much power in one area over an aquifer or multiple aquifers, and recognizing in some cases the importance of groundwater in some areas is greater than over others per capita. So just for instance, in our lawsuit, we put on evidence that the per capita water use in the area west and east of San Antonio is significantly higher than it is in the city of San Antonio. So despite the arguments that plaintiffs made that the case was necessary and it was the right time to address the issue, the EAA argued that it was not a good issue. It was a very specific case. There really was no conflict between the Fifth Circuit's decision and any other law out there. Because there is so much specificity about our facts, that it really didn't make sense to take the case, and the Supreme Court agreed with the EAA and refused review of the case. So that's my longest one to talk about. Slide. So that's all settled. We shouldn't be facing one person, one vote claims around our director districts. But if you need help, if something comes up, please let me know. This was what I was talking about before, that some districts were created with director districts that all one person, one vote, but also the water code itself in setting out what the default director district lines should look like is not consistent with one person, one vote. And you can look at that language in 36 or 59 subsection B of the water code slide. So I think this, am I talking about this case?
No, this is going to be Stacey's case. Thank you, Deborah.
Pass you to Stacey.
Before we move on to Stacey, Deborah, one quick question on that. Did the involvement of LULAC and MALDEF in the original districts come up?
Well, I brought it up. I brought it up, but it's sort of just more their hands were dirty, but it wasn't really technically relevant to anything. I mean, the legislature is who created the seats, but it was with the agreement. So I put that in my briefing and the argument whenever I could, because it really was with unclean hands. I mean, for instance, I argued from out of the gate, the statute of limitations should bar their Section 1983 claim, because the statute of limitations on Section 1983 is 2 years, and they knew of this problem in 1995 when the act passed, which with their support. So to come 20 years later and complain about the director district lines that they helped craft, even if they hadn't helped craft them, they should have sued about it earlier, but the courts didn't buy it because they don't want to stop voting rights from being adjudicated down the line. So it was a really interesting nexus of water management issues and voting issues. And so sometimes those come up for us in the GCB world, and they're a lot of fun. I'm just glad it came out right.
I thought it was interesting the court did not even address the disparity in the size of the districts within Bexar County. So,
yeah.
Okay, Stacey, we're going to move on to you. The Estrada and Vizino versus Brazos Valley GCD case, please.
Great. Thank you, Leah, for having me. And thanks, Greg, for that nice introduction about being youthful. I will take that comment all day long. We have an important ruling from the Fifth Circuit, the appellate court, that basically revived Vizino's case and gave us some answers to some really important questions. Now, remember that Vizino is a landowner adjacent to the city of Bryan, and he's been complaining that the city is producing a disproportionate amount of water from its small 3-acre tract and draining water under Vizino's land. And Vizino is not allowed to drill an offsetting well to the same magnitude. The city's well number 18, is an existing well, and Vizino's well would be a new well subject to the district's new spacing and acreage rules. Vizino wants the rules voided, and he brought equal protection and takings claims. And so Vizino is basically saying, restrict the city's permit to the same amount per acre that you would give to me, or give the same amount per acre, or give me the same amount per acre you gave to the city. And Vizino's saying it's a takings if you have different rules for me than for my neighbor, and you shouldn't let my neighbor produce more than me and drain my groundwater. Now, Mr. Strada, who's also on the board for the district, he filed suit for violation of his First Amendment rights because he was prevented from making public comment at a board meeting on a non-agenda item. And Mr. Strada was specifically asking the district to consider whether well number 18 was in fact an existing well that wasn't required to comply with the acreage and spacing rules, or if it was a new well. And he was prevented from asking that during a public comment. So at the trial court, everyone's claims were dismissed based upon different jurisdictional type issues, and that dismissal was appealed. And at the appellate court, the appellate court determined that Mr. Strada's First Amendment claim was properly dismissed. So he's out of the case, and his claim has, for a violation of the First Amendment, has been dismissed with prejudice. But the takings and equal protection claims should not have been dismissed, was the ruling from the court. And the ruling, importantly, does not determine at this point whether there was an actual taking or a violation of equal protection, because those things will be determined at the trial court. So we've got these, that's a little bit of background for you before we jump into these sort of 5 lessons that we learned from the appellate court. We now know that it's easier to sue districts in federal court. And we know that because GCDs and directors are not protected under 11th Amendment immunity because they are not arms of the state. If you're an arm of the state, you get 11th Amendment immunity, which shields states from money judgments in federal court. And it was determined that and confirmed that GCDs are not arms of the state subject to this 11th Amendment immunity. It's also been affirmed that landowners can now go straight to federal court to pursue federal takings claims, and they're no longer required to file them in state court. The law historically had been for a number of years that plaintiffs had to file suit, a federal takings claim in state court first unsuccessfully, and before they could file suit in federal court. Well, the law had changed between the time that the trial court made the decision and at the appellate court level, so this reversal on this issue was not surprising. But the end result being that it's now easier to sue GCDs in federal court. Another lesson that we learned is that takings and equal protection claims can be brought in federal court. There was an argument that the federal court should abstain from deciding the case because Texas law is unsettled, so it would be more appropriate for a state court to decide the case. The argument was that this case is really about the application of oil and gas to groundwater and that this is still unsettled under Texas law. Well, the appellate court disagreed and said, no, the fundamental issue is really about property rights and that groundwater rights are property rights. And it's too high level to generalize the Zenos claims as resting on unsettled questions on the application of oil and gas to groundwater. The third lesson that we've learned is that directors do not have the same First Amendment rights as the public. Remember, Director Strada wanted to step away from his board seat and sign in as a member of the public and make comment to the board. And it was determined at the appellate court level that the Texas Open Meetings Act can trump a First Amendment right to speech, and that a director's free speech rights are not violated when the director is barred from requesting non-agenda items to be added to a future agenda during public comment because the Open Meetings Act prohibits unnoticed issues to go before the board. So a director can't step away from their board seat and be an ordinary member of the public at its own board meetings. Another lesson that we learned is facts really do matter. And the court evaluated whether the takings and equal protections claims should be dismissed on the face of the pleadings for failing to state a claim. And the court said, no, that's not appropriate. There really needs to be further development of the facts at the trial court level before dismissal, given Zenos' allegations of disparity and intentional conduct. And the last lesson that we learned is that you should not treat persons who are similarly situated differently. So if well number 18 was in fact misclassified, which is sort of an underlying issue or suggestion in the case, if it was in fact misclassified and it should have been a new well, then we know that there's a problem because those acreage and spacing rules were not applied to the city's well, if in fact it was a new well. So we will need to remember to treat all persons similarly situated the same. Next slide, please. So let's talk about what remains to be determined at the trial court level now that we know what happened at the appellate court. And to me, it's even more interesting to evaluate what's going to happen at the trial court, because this case really gets at the heart of what is fair share. How do you define it and how do you provide it? And this case is now back in front of the judge, who was reversed on appeal at the Fifth Circuit. and in front of the same judge who said that regulation doesn't guarantee equal and identical outcomes. And Fazino requested a magistrate judge to actually preside over the trial, but the district would not agree to have a magistrate judge. So the same judge who was reversed on appeal, who also said that regulation shouldn't guarantee equal and identical outcomes, is going to be the judge presiding over this trial. And this judge is relatively new, but this is his first groundwater case. He's new to the bench, but he's very smart. He's handled very complex patent infringement cases prior to coming to the bench, and he is known for a very fast docket and for fast trials. So there's a trial scheduled for February in this case, and we are going to hopefully learn whether these rules are invalid, whether the application of the rules resulted in a taking or a deprivation of equal protection, whether takings claims can be brought against directors, whether injunctive relief is available in takings claims. After the appellate court decision, Fazino amended his lawsuit, and Mr. Strada was dropped from the suit because his claims failed to survive dismissal. So Mr. Strada is no longer involved in the case as a plaintiff. And Fazino also dropped his request for punitive damages. Through that amendment of the lawsuit, Mr. Fazino also clarified several facts. There's still this suggestion that well number 18 was perhaps misclassified, but there's also this real focus on what appears to be a loophole in the district's rules for existing wells. Specifically for existing wells that have no historic use production associated with it, acting as a production limit. And Fazino argues that the well number 18 has no production limit, and it should, because new users have production limits and historic users have production limits as well. And the reason why Fazino's well well number 18 doesn't have a production limit associated with it is because the way that the existing wells are defined under the district's rules, it includes wells drilled before the effective date, but also wells for which significant development occurred before the effective date. And so in this instance, well number 18 was drilled after the effective date, but still counted as an existing well based upon significant development that occurred before the effective date. And so Fazino is saying this loophole in this rules for well number 18 is well known by the district, and it's designed to prevent production of groundwater by some owners while allowing production from others, like the city of Bryan. Fazino is still arguing the rules should be voided. He's arguing that a correlative rights system should apply to all, and that there's no rational basis for giving a greater fair share to the city than it gives to an individual with an equal or greater amount of property. So this litigation really tests whether you can force a district to follow a purely correlative rights system, one where the amount that you can pump is based on the amount of surface acreage that you own. This litigation also forces issues that are not clearly developed in case law or outlined in Chapter 36, and in some instances appear to actually contradict Chapter 36. So we know that the Day case says that one purpose of regulation is to provide a fair share, but doesn't define fair share. The legislature hasn't defined fair share. And we know that Chapter 36 says that despite ownership of groundwater, a landowner isn't entitled to a specific amount of water. We know that Chapter 36 also authorizes a district to impose more restrictive permit conditions on new use. So the Day case says, correlative rights regulation is not mandatory to afford an opportunity for a fair share. And Chapter 36 says that you're not mandated to do acreage-based rules either. So it's really going to be interesting at this trial court level to see how the court addresses Fazino's arguments in light of where Chapter 36 and case law currently stands. And if Fazino is right and correlative rights system should be applied to all and is required to afford a fair share, then historic users will likely file takings claims because their investment-backed expectations cannot be met on purely correlative-based systems. So currently there's some pending motions to dismiss on some limitations issues and some other kind of still threshold issues on some of these takings and equal protection claims that are left. The briefing has been complete, but the court has not ruled yet. And this case is set for trial in February 2020. So we could get some really interesting answers soon.
Thank you, Stacey. I had a question, but you've already answered it, so I'll go ahead and move on to the next case, which I'll be covering, and I'm going to try and get through this quickly because we're already behind time. The Mountain Pure Texas LLC versus Natchez and Trinity Valley's Groundwater Conservation District. The case is currently pending before the Texas Supreme Court. This is an enforcement case that the district filed against the landowner, Mountain Pure Texas LLC, and its tenant, Ice River Springs Palestine, which was a water bottling company, for failure to obtain a permit. The district is now claiming that their improved spring requires a permit from the district as well. That underlying issue, that underlying fact, which is pretty unique to that situation, has not yet been determined. We haven't had any determination by any court as to whether or not an improved spring is a well that requires a permit. In the meantime, because they filed the suit, Ice River Springs canceled its lease with Mountain Pure and was dismissed from the suit. Mountain Pure has filed a number of cross complaints. I can't remember which answer they're on. I think it's number 6, in which they have filed multiple cross complaints, and that included a takings claim for the value of the lost lease with Ice River Springs. Next slide, please. The district court granted motions for summary judgment, and most of the cross complaints have been dismissed. However, the district court did not dismiss the takings claim, either under the motion for summary judgment or under the plea of jurisdiction. So because they didn't dismiss that one, there's been an interlocutory appeal on that issue alone. That went to the 12th Court of Appeals, and that appellate court ruled in favor of the district, holding that enforcement actions cannot be the cause of a takings claim. Go ahead and go to the next slide. That was based mainly on a Houston case, a case of City of Houston versus Carlson, and that decision from the 12th has been appealed to the Texas Supreme Court. The district has filed its reply. We don't know yet what the Supreme Court is going to do. Primary issues on appeal are: is a takings claim proper as a response to an enforcement suit? And secondly, what is the proper interpretation of that case, City of Houston versus Carlson? In that case, the City of Houston told a group of people in a condo that their condo was unsafe to habitate, and forced them all to vacate. They were forced to vacate for 3 years. At the end of that process, the City of Houston determined they didn't really have authority to require them to do that, and allowed them all to go back in, and they filed a takings claim for the temporary taking of their property for that 3-year period. The Supreme Court of Texas said, no, that was an enforcement issue and is not the proper basis of a takings claim. Now, the possible impact of the GCDs and all other administrative agencies, if enforcement suits or even administrative penalties might result in a takings claim litigation, that will greatly complicate enforcement issues. Takings claims are very long, drawn out, very involved, expert witness from economists and others that will really make a lot of these cases very, very expensive to prosecute. I believe the Supreme Court's going to dismiss. I'm a little surprised they haven't yet. The next step from the Supreme Court will either be to require full briefing on the issues and then decide whether or not to grant the petition, or they may grant the petition and schedule an oral argument and require a full briefing. So we'll see if they do either of those things, or just dismissed and let the 12th Court of Appeals opinion stand. Okay, our next person, I think we're going to go back to Deborah. Next slide, please. And this is going to be on state environmental laws. Deborah, go ahead.
All right, so this is just something we sort of wanted to bring to your attention as a legal issue. This came up when we were looking at some recent Supreme Court cases around regulating under the Clean Water Act discharges that directly impact groundwater, where they have a nexus connection to surface water. And a lot of times local governments, including groundwater districts, may not realize that they actually have a role to play with regard to protecting groundwater quality and state laws around water pollution. So I wanted to, in the context of these recent Supreme Court cases that look at related issues, make sure everyone was aware of Section 7.351 of the Texas Water Code, which allows local governments, including groundwater districts, to enforce state laws and the statutes and rules and permits issued thereunder that occur within their jurisdiction. And specifically relevant for our purposes are Chapter 16 of the Water Code, Chapter 26, which is where Clean Water Act permitting occurs in Texas, TPDES permits, and Section 404 permits, Chapter 28 water wells, and the Occupations Code, Chapter 1903. Slide. And in addition, other environmental laws such as Chapter 361 of the Health and Safety Code, which is the Solid Waste Disposal Act, and then some other, 371, which is used oil, 372 plumbing, but 382 is the Clean Air Act, and Chapter 401 is another, probably less useful, Radiation Control Act. Interestingly, the Edwards Aquifer Authority intervened in a suit that involved groundwater contamination, the Mulchi fire in Helotes, Texas, and we brought claims for violation of the Clean Air Act, among other things, in that suit. So, next slide. What this provision of the Water Code allows you to do, good slide from there. This is just sort of talking about, these are some of the laws that can be enforced, but what that chapter of the Water Code 7.351 allows districts to do is, if there's a violation of any of those laws occurring within the groundwater district's jurisdiction, they can provide notice to the state that that violation has occurred. And the state can either bring a suit, or the district can bring a suit, and then notice is required to the state. They become a necessary party, and fees are split. So the recovery would go 50% to the groundwater district, which is basically, it's kind of like a citizen suit enforcement action. But what we wanted to make sure that groundwater districts thought about, and here are the couple of Supreme Court cases that have recently been decided, and I'll talk about those just for a second. But what we wanted groundwater districts to recognize is, even if they don't have specific rules about water pollution or other sorts of pollution that could ultimately affect groundwater, solid waste, that they may have an enforcement role to play. And so therefore a way to get involved, a handle to get involved in issues of concern within their jurisdiction that they're worried about from the point of view of groundwater. So these two cases, County of Maui and Kinder Morgan, involved discharges which were to groundwater, but the groundwater was connected to surface water. And there's an important difference under Federal Clean Water Act and state water code provisions around clean water. In federal law, the feds only regulate surface water. They don't regulate specifically under the Clean Water Act discharges to groundwater unless they are connected to surface water sufficiently. And what the Supreme Court held in these two important recent cases is that where a discharge to groundwater, so it's called so we're talking about a point source discharge, so taking pollution and putting it into groundwater, where that's the functional equivalent of a direct discharge from a point source into navigable waters. So basically, in these cases, there was a discharge to groundwater, and then that groundwater led to surface water within a short distance. In those circumstances, a permit is required under the Clean Water Act for that discharge. Both of those cases are now back down to trial court, but that was the legal question that got decided. That was interesting and relevant reason. Slide. All right, this is mine. So just wanted to bring that all to your attention.
Okay, thank you, Deborah. Stacey, can you cover the LCR application in less than 5 minutes?
Absolutely. So remember, LCRA applied for a permit to produce 25,000 acre feet from 8 wells that in a well field design that was described by the general manager as unconventional because all 8 wells were in a straight line right up against the property line, but the wells still complied with the district's property line and spacing rules as to other wells. The application drew a large number of protests, and the GM also protested it. The ALJ denied party status to several landowners, specifically those who do not have wells or did not have an intention to drill a well, because merely owning groundwater is not sufficient to show a particularized injury. So we had kind of a consistent ruling there from the same ALJ who made that ruling on standing back in the NDOT/recharge case. The ALJs, there was a contested case hearing last fall, and the ALJs issued their proposal for decision on the parties that did get to participate in the contested case hearing. And there were several things that came out of this. Many of them are the parties within the contested case hearing are having concerns about even some of the things that came out of this and are asking for clarification on a number of points. This will go before the Lost Pines board sometime this fall. It was originally scheduled to be at the September meeting, but that has been continued. So what specifically came out of the PFD is when analyzing whether a proposed use could cause unreasonable impacts, you only look at the applicant's proposed use, not all district use. That was something that came out of the Bastrop proposal for decision and was continued here. The analysis of unreasonable impacts is necessarily very fact specific. You should use the latest model for analysis of impacts. So in that situation, the permit was analyzed under the old GAM, but then at the time, the application was analyzed under the old GAM, but at the time that the decision was made or the application was contested, the new GAM had been out, and the ALJ said, listen, you should use the best available data and science. There was a determination that compliance with spacing rules does not automatically satisfy the requirement under Chapter 36 and the district's rules to lessen interference. But the ALJs concluded that the combination of a pump test, monitoring wells, phasing, and curtailment do, and that this unconventional well configuration, as described by the general manager, was okay. You can issue a permit even if the authorized amount will exceed the MAG. That's something that we've seen before in some of these other permit contests. And then there was a whole slew of special conditions. And again, the parties are still trying to work through some of the issues with these, but nonetheless, here they are. The special conditions can vary from permit to permit, and settlement may play a part. There should be wells to monitor the effects of surface water, not just monitoring well agreement to monitor the effects on groundwater, but there should also be wells to monitor the effects on surface water. End user contract requirement is okay if you're using it to demonstrate demand or beneficial use. There's a lot of issues about this phasing formula and whether or not the district should have a rule if they're going to institute phasing. And the ALJ said it's okay, it can be imposed without a rule as a special condition. The ALJs also determined that the protestants should be involved in the phasing decisions of the permit and the renewal of the permit, which is a hot button issue for the parties and for the general manager, which would effectively, arguably, reopen a renewal or a phasing decision to another contested case hearing effectively, at least with those parties. Some folks have a problem with that and question whether that complies with Chapter 36, which mandates that renewals, as long as there are no changes, should really be automatic. Another special condition, there is authority to impose a monitoring well agreement and monitoring wells to do that. The ALJs concluded that there's no authority to impose a mitigation fund. As you know, several other permits in Lost Pines have a special condition in there that require those particular applicants or permittees to fund mitigation. Those came out of a settlement agreement, and the ALJ said that the district itself doesn't have authority to impose that. But if they're in a permit from a settlement, that's okay. The condition prohibiting discharge of groundwater into a surface water course pursuant to a bed and banks permit exceeds the district's authority. And you should use the DFC in place at the time for the basis as to whether you can move between these different phases. There is a question, well, should we use the DFC that is in effect now at the time that the permit's being issued, or should we use the DFC in place at the time that they're looking to move between phases? And the ALJ say use the current one, whatever that is at that point in time. So again, this will be considered by the board this fall. And the only other thing that I'll say about kind of legally is these special conditions, I just think that I know there's discretion and authority for districts to do that in Chapter 36, but I think that they're ultimately really designed for very unique circumstances. and that therefore you wouldn't need to have in your rules. But if you are starting to impose special conditions and regularly in certain types of permits, I think that districts should ask themselves if you need a rule on it. Because sometimes the exercise of special conditions could inadvertently create unfair or partial treatment of permittees, and that's really one of the issues from my perspective that's going on in this application protest.
Thank you, Stacey, very much. It's going to be interesting to see what happens there, and I can't comment because I represent the board in that case.
And
Right.
I represent Recharge as well. So, but I think that I tried to give a balanced perspective of the issues.
And I think that you did. We'll have to find out from Emily whether she agrees. Let's go to the next slide, and I want to rocket through this one. This is a test by the Trinity Edwards Springs Protection Association versus the Barton Springs District and Need More Water LLC. This has really got narrowed down to a very narrow issue that doesn't impact a lot of districts as to whether or not a well that was in place but may have been not utilized for a long time and perhaps even was deteriorated counts as an existing well under the law that specifically expanded the boundaries of the Barton Springs District. If it is an existing well, then they were entitled to a temporary permit and later a permanent permit without a hearing. And what happened is TESPA protested the application of Need More. And go ahead and go to the next slide. That was sent to the State Office of Administrative Hearings. The administrative law judge there granted summary disposition dismissing that protest, saying the legislature didn't provide a method for a protest. So the legislature, by creating a process to issue a permit that doesn't allow neighbors to protest that application, has led to this argument. Now, the first argument, and what we're going to have to determine at the court level, is whether or not that was truly an existing well. And that's very fact specific to that situation. However, if it was an existing well, the next argument is going to be whether or not that statute violates the rights of the neighbors to protect their property rights by granting automatic, essentially, historic use permits to existing users. So that's all I'm going to say about that one. If anybody has any questions, please ask me about it. Let's go ahead and go to the next slide. And Deborah, if we could go through this one really quick. Go to the next slide, please. This is the pipeline cases in the Hill Country. Deborah, you're going to cover that. We have very little time left, so rock it, doc.
Sure. There's several cases pending right now that have to do with Kinder Morgan building a pipeline and allegations that that pipeline is impacting endangered species, requires a take permit, requires an environmental impact assessment or an environmental, impact statement or assessment under NEPA. Slide. The city of Austin and Barton Springs District and others have brought suit against the pipeline, raising different causes of action. Slide. And there was a spill that was after a lawsuit was already brought, there was a spill. And the argument is that the spill contaminated the Trinity aquifer, also that it's impacting the Edwards aquifer, although that seems to be less clear. Slide. And there are multiple suits. One of them has to do with the permitting for the pipeline itself and whether it's appropriate and whether it should have gone through FERC and gotten a separate permit that it didn't get. And the pipeline argued that it was only intrastate and didn't require that kind of permit. Slide. So this is a different slide. So basically,
we have these final issues here and about 2 minutes to cover them. We thought it was important to talk about what unresolved questions are out there, what's likely to lead to litigation, and how your district should do everything it can to avoid being the test case. The first one comes up is ownership issues, and we heard yesterday or first day, I guess, about the question of water utilities and their groundwater use based on their service areas versus ownership by their customers and others within those service areas. And also the permittee's property rights versus the neighbor's property rights, which comes up both in Zeno and in the TESPA case. So I'd like some quick comments from both of you two about where you think that's going to come. Stacey, let's start with you.
Sure, I have questions about service area, and if you're going to give a consideration to the service area need, is it 1-to-1 with the property owner's surface acreage, or should it be some other allocation? I think that the very few districts that are doing it, most of them recite kind of what Chapter 36 says, but not really explain what they're doing or how they're doing it. There are a few districts that limit it to gallons per day. I just think it's going to. We need more clarification or it's going to be litigated.
There you go. Deborah?
This is just a tricky area of really potential taking lawsuits. And I think that if you haven't already been using groundwater and relying on it, then it's hard to say that the government has taken something from you by not allowing you to use it in the future and establish the elements of a successful takings claim. Because if you have access to groundwater and you can get it from somewhere else, then it's just a cost issue. And taking is basically about essentially making your property valueless. So unless you have really extreme facts, I think those are going to be hard cases to win. So I think districts just have to do the best they can to be reasonable to apportion water to those who need it within their jurisdiction.
I think an interesting aspect here is that some districts have rules that say we will give you access to the groundwater beneath that property, essentially included in your permit, only if you, the utility, have an ordinance or a rule that prohibits that landowner from drilling their own well. And certainly almost all the rules that recognize the service area make adjustments for landowners that already have their own wells. Okay, beneficial use. So we know the water code provides a definition of beneficial use that allows just about anything under the sun, including anything that's beneficial to the user. But we have some discussions about this. The first question comes up is, are speculative permits, I plan to sell this water to somebody someplace someday, qualify as a beneficial use? I know those permits have been issued. I know that those permits are likely to result in litigation if they're not issued, and sometimes even if they are issued. So the question here is that a beneficial use? Deborah, I want to start with you because I know what Stacey's opinion is.
My clients have not been interested in giving permits under those facts. I think that it's hard to say when water supply is tight, there's not enough to go around, and they're not far enough along in the process. Most of my clients have not been very keen to give up water when folks need it on the ground. And so I think that we're just trying to make money off of water in the future without a clear need is not that sympathetic. Now, if there's plenty of water to go around, maybe that's more feasible for different districts.
Stacey?
I think this comes up more in districts that have need or demand-based permitting. Obviously, if you have acreage rules, it's easier to make a determination on that permit. I wonder whether districts should have, if they're doing demand-based or reasonable-based use, if they should define, how much of a demand in what period, 5-10-year period. That invites a whole nother mess of problems, but it would help provide more clarity to whether or not the demand is really in the short term or more of a long term and speculative. Well, I guess you mean speculative in the sense that they might not have a contract to provide the water.
Exactly. And both of those issues came up with both 4-Star and the recharge NDOT permit, where that district issues 5-year permits, but if they hope to sell that water through a large pipeline, they need to know they're going to have that water much longer into the future. Okay, what about pond use? Is it beneficial because of the definition of waste to counter that definition of beneficial use, that putting water into a surface water stream is pond use, is a vanity pond use? Is it okay to put water into a surface stream? Are those beneficial uses? Are those going to be considered waste? Deborah, let's start with you.
Again, this is really dependent on the district and how far they want to go. Certainly, these have been permitted by districts. I think that and TCQ allows this in surface water use. So I think it's really controversial. I am waiting for a client to refuse to allow it and then to get sued over it. But there's a lot of evaporation in Texas, and it is going to get harder and harder to have these places just be, pure vanity with no actual application.
Stacey?
I don't know.
I think it's hard to limit the broad definition of beneficial use, and clearly if, it's considered to be a beneficial use by the user, it gives the user pleasure, then it would constitute beneficial use. And, that AG opinion that came out about you can't limit the definition of agricultural use, you can't limit the definition of beneficial use. And so this came up in Lone Star, and currently Lone Star is proposing, they had a rule that limited the amount of groundwater that could be put into a surface impoundment for these vanity ponds, and then had conservation losses as a requirement. And under the current proposed revised rules, they're removing the restriction on how much water can be put into it, but maintaining the conservation standards for miscellaneous losses.
The subsidence district in Houston at one point proposed that they were no longer going to issue new permits for new wells for pond use or for detention pond use. And the developers basically accused us of trying to take their firstborn children. The waste issue is utility line loss considered a waste. Stacey?
That's a tough one. Again, I look to the definition of waste, and I'm hesitant to, add additional things to that. I think there's pros and cons to doing that. It certainly can create an enforcement issue, at least in the districts that I'm familiar with.
Deborah?
Yeah, we have required for permits within one of my districts to not waste over 15% and sort of looked at industry standards. And when it's over that amount, we won't permit it. So, I think it's reasonable for districts to say, look, we're not permitting you so that all your water can leak. So I do think over a certain, some waste, I think is just happens, but I think it's reasonable to put a percentage number on that.
Well, I think I've gotten a red light here with Leah popping up on the screen. Some other issues.
We are more than 5 minutes over, and so I don't want to go too much longer. But really do appreciate you all being a part of the summit, providing your great expertise on all of these tricky legal issues out there.